What you're about to hear is not a rumor, not a political exaggeration, and not another recycled Trump controversy. It's a moment that stunned even veteran courtroom reporters. Because in a silent federal courtroom, a judge did something that many people believed would never happen to a former president. She looked directly at Donald Trump and made it clear that the next step would not be another warning, not another fine, but jail. And what makes this moment so explosive is not just what Trump did, but how deliberately he did it, how clearly he crossed a line he had personally agreed not to cross, and how this confrontation exposes a deeper question that cuts to the core of American democracy. What happens when someone who has spent a lifetime defying rules finally meets a system that refuses to bend? Because by the end of this video, you're going to understand why legal experts say this hearing may have permanently changed Trump's legal strategy, why judges across the country are watching closely, and why this wasn't just a courtroom scolding. It was a warning shot that could reshape everything that comes next. Imagine the story beginning not with noise, but with pressure, the kind of invisible pressure that settles over a room when something historic is about to happen. A federal courtroom so quiet that even seasoned reporters instinctively stop typing, sensing that whatever comes next will not be routine. And in that silence sits Donald Trump, a man who has spent decades controlling rooms through sheer force of personality. Now confined to a wooden chair flanked by lawyers whose faces betray a rare tension. Because this is not a rally, not a press conference, not a media spectacle he can dominate. This is a courtroom, and the power here does not belong to him. And the reason this moment matters, the reason it feels different from every other Trump controversy you've ever seen, is because this time the evidence isn't interpretive. It isn't circumstantial. It isn't filtered through political spin. It's written, time stamped, and undeniable. And what you're about to witness is the slow collision between a man who believes rules bend around him and a judge who has decided that they won't. A collision so stark that by the end of this story, even Trump's most aggressive legal strategies will look suddenly fragile. Because when a federal judge stops warning and starts documenting defiance, the system itself is telling you that something has fundamentally changed. And to understand why this hearing sent shockwaves through the legal world, you have to understand that this wasn't about one angry outburst or one reckless post. This was the culmination of months of restraint, patience, and quiet escalation. A fuse that had been burning slowly ever since Trump left office, with classified documents that never should have left government control. Documents that would later become the backbone of a case that already carried historic weight before Trump ever typed a single word on social media. Because from the very beginning, this judge was walking a tightrope that almost no one in modern American history has had to walk, tasked with treating a former president like any other defendant, while also managing the reality that this defendant commands an audience of millions and has a long, well documented habit of turning legal pressure into political theater. And that is why early in the case, the court issued a protective order, not as a punishment, not as a gag meant to silence political speech, but as a safeguard, a legal boundary drawn clearly and carefully to protect witnesses, preserve sealed evidence, and prevent jury contamination. An order written in plain language, reviewed by Trump's legal team, signed by them, acknowledged by them, eliminating any reasonable claim that the rules were unclear or unfair. And for a time, Trump appeared to comply, or at least perform compliance, posting statements that hovered just below the threshold of violation, testing how far he could go without triggering consequences. A pattern familiar to anyone who has watched his legal battles unfold. Because Trump's instinct has always been the same: push until someone pushes back, then push again. And for weeks, that strategy seemed to work until December 10th, the day when calculation gave way to instinct, and Trump posted messages that prosecutors would later describe as a textbook case of contempt. Messages that didn't merely hint or insinuate, but explicitly named a confidential witness, described classified materials under seal, and framed the case in a way that directly contradicted the protective order's most explicit prohibitions. And this is the point where everything shifts, because violating a court order is not political speech. It is not campaign rhetoric. It is a challenge to judicial authority itself. And judges take that personally, not out of ego, but out of necessity. Because if court orders become optional, the entire system collapses. And when prosecutors filed their motion detailing the violations, complete with screenshots and timestamps that showed exactly when the posts were made and exactly how they conflicted with the order, legal observers knew this hearing would be different because there was nothing abstract left to argue. This was Trump's own words against a document he had agreed to follow. And when the hearing finally began, the calm almost felt deceptive, with both sides presenting arguments in measured tones. Trump's attorneys leaning heavily on the First Amendment, framing the posts as general commentary, while prosecutors countered with a simple but devastating point that free speech does not include the right to ignore binding court orders. And throughout it all, the judge listened, asked questions, took notes, revealing nothing until she did something that would change the entire energy of the room, pulling up the protective order on a screen visible to everyone and beginning to read it aloud, slowly, deliberately, not skipping ahead, not summarizing, but reading it word for word. And then, after each clause, placing Trump's post beside it one by one, turning the courtroom into a live demonstration of defiance versus authority. And as this comparison unfolded, the silence deepened because this wasn't about interpretation anymore. It was about contradiction, clear and unmistakable. And when Trump's lead attorney tried to interrupt, the judge raised her hand, signaling that the time for argument had passed. And then she turned directly toward Trump, addressing him not as a political figure, not as a former president, but as a defendant, reminding him that a court order is not a suggestion, not a guideline, not something to be creatively interpreted, but a binding legal directive. And in that moment, the myth of exceptionalism cracked just enough for everyone in the room to feel it, because this was no longer about Trump versus his critics. This was Trump versus the system itself. And the system was done pretending this was a misunderstanding. Because once a judge decides that patience has been mistaken for weakness, the entire posture of a courtroom changes. And that shift was visible in the smallest details. In the way the judge no longer leaned back but sat forward. In the way her questions stopped inviting explanation and started demanding accountability. And in the way Trump's legal team, usually aggressive and expansive, suddenly became restrained, careful, almost defensive, as if they understood that this was no longer a hearing they could win through rhetoric alone. And as the judge continued her analysis, she began reconstructing the timeline, not emotionally but surgically, laying out how the protective order had been issued, how its language had been discussed and clarified, how Trump's attorneys had acknowledged its scope, and how the court had deliberately chosen restraint over restriction, trusting that compliance would follow a trust that now appeared badly misplaced. And this is where the deeper psychology of the moment comes into focus. Because for Trump, rules have always been something to negotiate, to test, to challenge publicly, until they either collapse or bend. A strategy that has served him well in business, politics, and media. But the courtroom is different because here the incentives are inverted. Defiance does not project strength, it invites sanction. And yet Trump's instincts drove him to do what he has always done, to speak, to frame, to provoke, to assert control over the narrative, even when the cost of doing so was clearly spelled out in black and white. And as the judge continued reading aloud the exact language of the protective order, emphasizing phrases like shall not and is prohibited from, her voice reportedly took on a sharper edge. Not loud, not theatrical, but unmistakably firm. The tone of someone explaining something that should never have needed explanation. And when she reached the section prohibiting the disclosure of witness identities, she paused, looked up, and then read Trump's post naming a confidential witness in full. And that pause, according to people in the room, felt like an eternity because it forced everyone present to confront the simplicity of the violation. This wasn't nuanced. It wasn't accidental. It was direct. And as she moved to the provisions dealing with classified materials under seal and then read Trump's descriptions of specific documents, the disconnect became even more glaring. And at that point, the First Amendment argument effectively collapsed under its own weight because no constitutional right grants permission to violate a court order you have agreed to follow. And the judge made that point explicitly, stating that Trump was free to defend himself publicly within the boundaries of the law, but not outside them. And this distinction matters deeply because it reveals the core tension at the heart of this case. Trump's belief that his public voice is inseparable from his identity, and the court's insistence that legal obligations do not disappear because a defendant has a platform. And as this tension played out, observers noted Trump's physical reactions, the tightening of his jaw, the way he leaned forward as if preparing to speak, only to be stopped by hurried notes from his attorneys. And those notes themselves told a story because they reflected an understanding that any outburst, any reaction, any attempt to argue directly with the judge would only make things worse. And this dynamic, Trump restrained by his own lawyers, is itself rare because it underscores how serious the situation had become. And when the judge finally addressed Trump directly, reminding him that court orders are binding directives, not creative guidelines, her words landed with particular force because they stripped away the ambiguity Trump often exploits, leaving no room for interpretation. And she used the phrase flagrant and intentional, language that carries heavy legal consequences because it signals that the court believes the violation was not accidental or negligent, but deliberate. And in legal terms, intent changes everything because it justifies stronger sanctions. And as she articulated this finding, she explained that the court had gone out of its way to accommodate Trump's unique circumstances, tailoring the order to allow political speech while still protecting the process, and that this accommodation had been repaid with defiance. And this is where the broader implications begin to emerge. Because if a former president can ignore court orders without consequence, what message does that send to other defendants, to witnesses, to the public? And as the judge spoke, it became clear that she was not just addressing Trump. She was defending the authority of the judiciary itself. And when she announced that she was holding Trump in contempt of court, the words were delivered without drama, but their impact was undeniable because contempt is not symbolic. It is a finding that the court's authority has been challenged and must be reaffirmed. And the fines that followed, $50,000 per violation totaling $250,000, were significant, not because of their financial impact on Trump, but because of what they represented, a formal escalation, a line crossed, and yet even then the judge made it clear that money was not the primary concern because fines alone had failed to deter similar behavior in other cases. And that acknowledgment set the stage for what would come next. The warning that transformed this hearing from another Trump legal setback into a moment that legal analysts would describe as a turning point, because the judge stated plainly that any future violation of the protective order would result in custodial sanctions, meaning jail time. And this statement cannot be overstated in its significance because federal judges do not issue such warnings lightly, especially not against defendants with extensive security concerns and political influence. And the fact that she did so indicates a belief that lesser sanctions would not suffice. And as she explained her reasoning, she emphasized that she had no desire to jail anyone, that incarceration is always a last resort, but that the court's authority must be respected, and that continued defiance left her with no alternative. And in that moment, the room reportedly felt different, heavier, because for the first time, the possibility of Trump being taken into custody was no longer theoretical. It was explicitly on the table. And this is where the narrative connects to a much larger pattern because Trump's legal history is marked by repeated clashes with judges, over speech restrictions from attacks on judges and their families in New York criminal proceedings to repeated violations of gag orders in the January 6th case to sanctions and civil fraud trials for targeting court staff. And in each instance, Trump paid fines, absorbed warnings, and continued pushing, reinforcing the perception that the ultimate sanction would never be imposed, that there was always another chance, another warning, another fine. But this hearing suggested that assumption may finally be wrong because this judge signaled a willingness to do what others had not, to escalate beyond financial penalties if necessary. And as the hearing drew to a close, the image that lingered was not of outrage or spectacle, but of containment. A man accustomed to dominating narratives, now confined by rules he could not bend. And that image matters because it represents a potential shift in how Trump's legal battles will unfold, a moment where the system asserted itself with clarity and resolve. And as Trump left the courtroom surrounded by security and attorneys, the question that hung in the air was not whether he would pay the fine, but whether he would change his behavior. Because the next violation, if it comes, will not be met with words or warnings, but with action. And that is why this first chapter of the story matters so deeply, because it sets the stakes for everything that follows, not just in this case, but in the broader struggle between individual power and institutional authority. A struggle that is far from over and whose outcome will shape how history remembers this moment, not as another Trump controversy, but as the point where the judiciary finally drew a line and meant it, to understand why this confrontation carried so much weight. Why legal analysts immediately began describing it as a turning point rather than just another Trump courtroom clash. You have to zoom out beyond that single hearing and look at the deeper architecture of the case itself, because what unfolded in that room on that day did not happen in a vacuum. It was the result of a slow, deliberate buildup that began the moment Trump left office and carried boxes of classified materials with him. Materials that by law belong to the United States government. Materials governed by some of the strictest handling rules in the entire federal system. And from the very start, this case was different from Trump's other legal entanglements because it wasn't rooted in business disputes, campaign finance questions, or political rhetoric. It was rooted in national security, in the question of who controls sensitive information and what happens when someone believes their status exempts them from the rules that apply to everyone else. And that is why prosecutors approached it cautiously, methodically, aware that every step would be scrutinized not just legally, but politically. And that same awareness guided the judge's early decisions because she understood that any perception of unfairness, an overreach or bias could be weaponized instantly, which is why her initial posture was one of restraint, granting extensions, allowing arguments to fully develop, and issuing a protective order that was narrowly tailored rather than sweeping. An order designed not to silence Trump, but to contain risk, to ensure that witnesses would not be exposed, that classified information would not be compromised, and that potential jurors would not be influenced by public disclosures. And this is where the story reveals something crucial about Trump's relationship with legal boundaries. Because the protective order was not imposed suddenly or arbitrarily, it was discussed, refined, and agreed to. Trump's attorneys actively participated in shaping its scope, asked questions, sought clarifications, and ultimately signed off on it, creating a clear record that the restrictions were understood. And for weeks afterward, Trump's behavior followed a familiar pattern, one that legal observers have seen across multiple cases, where he hovers near the edge of compliance, making statements that provoke but do not quite violate, statements that test how aggressively the court will respond. And in many cases, that strategy has worked because judges often prefer to warn rather than punish, especially when dealing with high profile defendants. But December 10th marked a break from that pattern because the posts Trump made on that day were not ambiguous. They were not cleverly worded to avoid direct conflict. They were explicit, naming a confidential witness outright, describing sealed evidence in ways that left little doubt about what he was referencing, and framing the case in a narrative that prosecutors immediately recognized as dangerous, not just legally, but practically, because once information like that is released, it cannot be contained again. And this is where the psychology of escalation comes into play, because Trump has long operated on the belief that escalation favors him, that pushing harder forces institutions to back down. And in politics, that instinct has often been rewarded. But in the legal system, escalation triggers consequences. And when prosecutors filed their motion detailing the violations, they did so with unusual speed and precision, aware that delay could be interpreted as weakness. And the motion itself was devastatingly simple, laying out the protective orders language, placing Trump's post beside it, and allowing the contrast to speak for itself. And as this motion circulated among legal analysts, a consensus began to form that this hearing would not end quietly because the violations were too clear to ignore and too public to downplay. And yet, even then, few predicted just how far the judge would go, because Trump's history had conditioned observers to expect restraint, warnings, fines, but not explicit threats of custody, and that history matters. Because Trump's relationship with judges has been adversarial almost by default, stretching back years, long before his presidency, with a pattern that repeats itself across jurisdictions. Trump attacks, judges warn, Trump pushes again, fines are imposed, and the cycle continues, reinforcing the belief that the system will bend rather than break. And that belief was strengthened during his presidency, when the extraordinary nature of his office created additional hesitation, additional caution, additional layers of deference. But now, as a private citizen facing criminal exposure, that buffer has eroded. And the judge in this case appeared acutely aware of that shift, because her language during the hearing reflected not just frustration but a sense of responsibility and understanding that failing to enforce the order would undermine not only this case but the credibility of the court itself. And this is why she took the time to methodically walk through the evidence in open court, because transparency is a form of authority. It demonstrates that decisions are based on facts rather than emotion, and by reading the order aloud and comparing it directly to Trump's posts, she removed any plausible claim that the ruling was subjective or politically motivated, turning the hearing into a public record of cause and effect. And as she did so, the courtroom became a microcosm of a larger struggle between a defendant who views constraints as challenges and a system that requires obedience to function. And that struggle is not abstract. It has real consequences, because witnesses who are named face risks. Classified information that is discussed publicly loses its protection. And jurors who are exposed to detailed narratives before trial may be influenced in ways that undermine fairness. And these are not theoretical concerns. They are the reasons protective orders exist in the first place. And the judge made that point implicitly by emphasizing that the order was designed to protect people and processes and not to punish speech in this framing matters because it undercuts the argument that Trump was being singled out unfairly, instead positioning the court as responding to conduct, not identity. And as the hearing progressed, observers noted how Trump's demeanor shifted from confidence to irritation to something closer to calculation, as if he were reassessing whether his usual tactics would work in this environment. And that reassessment is significant because it suggests that the warning may have landed in a way others did not. And yet, Trump's history also suggests that instinct often overrides caution, that the impulse to respond publicly to frame events on his terms is deeply ingrained, which is why the judge's explicit warning about custodial sanctions carries such weight because it transforms future violations from symbolic acts into concrete risks. And this transformation reverberates beyond this single case because other judges overseeing Trump related proceedings are watching closely. Legal experts are parsing every word of the ruling, and the broader legal community is grappling with what enforcement looks like when the defendant is a former president with unparalleled visibility. And that is why part two of this story is not just about background. It is about context, about understanding how a pattern of boundary testing behavior collided with a system that finally decided it could no longer absorb the impact. And as this case moves forward, that collision will shape every decision, every filing, every public statement, because the warning issued in that courtroom did not expire when the hearing ended. It lingers hanging over every future post, every interview, every moment where Trump is tempted to assert control over the narrative, reminding him that this time the consequences are not abstract. And that realization, whether it alters his behavior or provokes further defiance, is what makes the next chapter of this story impossible to ignore. The precise moment when the abstract weight of legal theory gives way to the raw mechanics of power. Because once the judge completed her meticulous comparison of the protective order in Trump's post, the courtroom crossed an invisible threshold, moving from analysis into consequence. And this shift is crucial to understand because courts are designed to be slow, deliberate, and procedural. Yet there are rare moments when the machinery accelerates, not out of emotion but out of necessity. And this was one of those moments because the judge recognized that what she was confronting was not merely a violation, but a pattern, a behavioral instinct that, if left unchecked, would continue to undermine the authority of the court. And as she articulated her reasoning, she did so with language that legal experts immediately recognized as carefully chosen, emphasizing not just the fact of violation but the intent behind it, explaining that intent matters because it distinguishes between someone who stumbles into noncompliance and someone who knowingly walks past a clearly marked boundary. And in Trump's case, the judge made it clear she believed this was the latter, noting that the order had been discussed, acknowledged, and understood, that the posts were made deliberately and publicly, and that the timing of those posts, coming after weeks of boundary testing, suggested escalation rather than accident. And this framing transformed the hearing from a dispute over speech into an examination of defiance. And defiance is something courts are institutionally designed to confront because if a court cannot enforce its own orders, it ceases to function. And as the judge continued, she addressed a point that often gets lost in public commentary, explaining that protective orders exist not to shield prosecutors from criticism, but to protect the integrity of the process itself. To ensure that witnesses are not intimidated, that sensitive information is not compromised, and that jurors are not exposed to narratives that could prejudice their judgment before evidence is formally presented. And by grounding her ruling in these principles, she removed the argument from the political realm entirely, anchoring it instead in the foundational responsibilities of the judiciary. And this is where the emotional temperature of the room reportedly rose because Trump's attorneys, who had leaned heavily on constitutional rhetoric earlier, now faced a framework that left little room for rebuttal. And observers noted subtle but telling changes in their posture. Fewer interruptions, shorter responses, a noticeable shift from offense to containment, as if their primary objective had become damage control rather than persuasion. And throughout this exchange, Trump himself became a study in restrained reaction, his face betraying flashes of irritation and disbelief, his body language suggesting an urge to respond that he resisted only with effort, a dynamic that underscored how unnatural this environment is for him. Because Trump thrives in spaces where reaction itself is power, where responding loudly and immediately reinforces dominance. But the courtroom strips that away, replacing it with a structure where silence is often the only safe option. And as the judge reached the conclusion of her analysis, she paused, allowing the implications of her findings to settle. And that pause mattered because it signaled deliberation rather than impulse, reinforcing the legitimacy of what was about to come next. And when she announced the contempt finding, she did so without flourish, stating simply that the court found Trump in contempt for violating the protective order. A declaration that carries both symbolic and practical weight because contempt is the mechanism by which courts assert their authority. And its use signals that the line between tolerance and enforcement has been crossed. And then came the fines, 50,000 for each identified violation. 5 violations in total adding up to $250,000. A figure that immediately dominated headlines, but which in context served a more nuanced purpose because the judge herself acknowledged that financial penalties alone had not proven effective deterrence in Trump's past cases. And this acknowledgement is critical because it reveals an awareness of behavioral